just make sure your cell phones are off or on silent. Silence or stand. Oyez, oyez, oyez. Let all manner of persons having anything to say or do at this His Majesty's Grand Court holding here this day before Her Ladyship, the Chief Justice, the Honorable Chief Justice Margaret Ramsey Hill, and the Honorable Justice Peabody, the Honorable Justice Richards QC, the Honorable Justice Doyle, and the Honorable Justice Carter. Draw nigh and give their attendance, and they shall be heard. Oyez, oyez, oyez. God save the King.
Good morning. It is wonderful to have all of you here. I welcome the Governor. Your Excellency, thank you for coming as usual. The Deputy Premier. I'm not sure if you're acting, sir, if your senior is simply late. We have a very special guest this morning. He's Sir Anthony Smelly, the Chief Justice retired of the Cayman Islands. We have other judicial colleagues sitting in the galleries. I note the attendance of Mr. St. John Stevens in particular. Welcome, DG. Can I say it's exceptionally good to see you? And I feel reassured. There was much said, and I can see you now in the flesh that you are as ever you were, hale and hearty. A welcome to your deputy, I think, and if not, Gloria McLean-Nixon and Strand Bodden and Eric Bush are the chief officers, all members of the House of Parliament. Forgive me if I don't get the protocol correct. I rely on Madam Attorney this morning to establish protocol. I'm simply greeting my friends, and in no particular order. So I see my Auntie Heather and other members of Cabinet, and of course our new Speaker, Catherine Wilkes, the youngest ever to grace that office, and then we have another female in high office in Cayman. You have to watch out. I'm going to invite Pastor Andrew Ebanks, I think it is of the Agape Family Worship Center, to commence the proceedings for us by leading us in prayer.
Let us pray. Almighty God, we thank you for this day, and we invite your presence here in this room with us today. That, Lord, even though this is not a church service, we invite your presence here today, Lord, because we ask for your divine wisdom and guidance to rest upon this court and this house. Lord, this is not a place for revenge or retribution, but a place for due process, justice, truth, and rightly delivered verdicts. And so our prayer today is, first of all, a prayer of gratitude. We are thankful because we live in a nation where we are not required to live in lawlessness or chaos, but we have laws to guide our actions and our interactions with one another. That we may live according to the wisdom that you have given for the betterment of our islands and this world. We are thankful for the freedom that we have and the opportunity to make our voices be heard. And we are thankful for those who are engaged in the many facets of the creation and enforcement of our laws, and those who serve this court in particular. We pray for the judges, both past and present, the officers of this court, the attorneys who stand at this bar to plead their causes before this bench. May they sense your hand in their endeavors, and may they seek your guidance in their life. May they learn to trust in you and turn to you in all matters. May you grant them wisdom, understanding, and compassion, and may they pursue justice, that truth may prevail, that false claims will be dropped, and the innocent vindicated and protected. And so we recall the words of the prophet Micah today, that he has shown you, O man, what is good. And what does the Lord require of you but to act justly, to love mercy, and walk humbly with your God. Let this be the place where truth and mercy meet. And may this court and this courtroom be filled with the confidence of your wisdom and the generosity of your mercy and power and love. In Jesus' name we pray. Amen.
Amen. Thank you very much, Pastor Andrew. Before I turn to Madam Attorney, I'm just going to say it was remiss of me not to welcome Sir Alden, but I didn't welcome any other lawyers, because we're simply in a place where you usually do business. But again, remiss of me. I make mention of my sister, Justice Marlene Carter. She sits with us on the bench today because she's not fulfilling her ordinary, temporary judge role, but she is actually acting in my substantive post, the one that was vacant on my appointment to Chief Justice. With any luck, it augurs well for her future. For as long as she is acting, we say that we're very happy to have her. I have a very, very, very special guest. I welcome from Texas, the Honorable William D. Wallace. Judge Wallace is a district judge for the 378th Judicial District Court in Ellis County, Texas. He is here on vacation, but seemingly decided to turn a part of his visit to the Cayman Islands into a busman's holiday. Judge Wallace presides over family cases primarily and asked in correspondence if he could meet his counterpart on our bench. Well, I thought we could do better than that. And so I invited him to the opening so that he could meet all of us. He accepted, and it is with pleasure I extend him a warm welcome, a Cayman kind welcome, to both him and his wife, who has attended with him. Welcome, Judge. Good to have you here. All right. We're going to get on with the proceedings. I'm free to tell you that I did a Google word search on my speech, which currently contains 4,976 words. And according to Google, it would take me 38 minutes to deliver it. I'm not limited, because I am the chief. But as I sit here, I'm considering how many ways I can chop it down so that you don't have to stay with me past the lunch hour. I'm going to invite the Honorable Acting Attorney General, Ms. Reshma Sharma, QC, to move the motion for the opening of the court. Madam Attorney. My Lady Chief Justice. Did I say QC? KC. I still call him Chief Justice. But I obviously, but there's a time lag in my brain. Ms. Reshma Sharma, KC.
Thank you, my Lady Chief Justice. My Lady Chief Justice, Honourable Judges of the Grand Court, Honourable Chief Magistrate and other magistrates, President of the Justices of Peace Association, Director of Public Prosecutions, Council Member of the Cayman Islands Legal Practitioners Association, special guests, distinguished colleagues at the public and private bars, ladies and gentlemen. At your invitation, my Lady Chief Justice, I rise to move the motion for the opening of the Grand Court for the year 2023. And as is customary, I crave your indulgence to offer some observations on the past year. But before doing so, my Lady, please permit me to join you in also recognizing His Excellency the Governor, the Honourable Deputy Premier, the Honourable Deputy Governor, other Cabinet colleagues, the Honourable Speaker, Members of Parliament, Chief Officers, Visiting Justice William Wallace, and other specially invited guests who are here with us. Their presence today in these court proceedings reflects their continued support for the administration of justice. Permit me also, my Lady, to extend the apologies of the Honourable Attorney General, Mr. Samuel Bulgen, KC, who is currently attending the Financial Action Task Force, FATF, joint group meeting overseas. I'll speak more to this particular subject later on, but at this stage, I would like to simply convey his greetings to you and the judiciary on this occasion. My Lady, may I pay special tribute to His Excellency the Governor. I had the privilege of welcoming him to his first Grand Court opening in 2019 when I addressed this honourable court at its opening. And today note that this will be his last such event before he departs these shores in March. During his tenure, His Excellency firmly supported the administration of justice. He was also a staunch proponent for the rule of law, in addition to his other pursuits such as running marathons and playing the steel pan. He'll be very much missed, and on behalf of those gathered here today, my Lady, I extend to him our very best wishes for his future endeavours, wherever they may take him. And on this occasion, my Lady, it is only fitting that we observe the passing of Her Majesty Queen Elizabeth II in September of 2022. Historically, the sovereign played a pivotal role in the enforcement of law and the establishment of a system of justice from which arose the concept of the sovereign as the fount of justice. In modern times, however, that role became symbolic, with the sovereign as the figure in whose name justice was carried out and law and order maintained. Criminal prosecutions, for example, have been brought in her name against those charged, and senior and distinguished practitioners were, up until 2021, appointed as Queen's Counsel, or they will now be known as King's Counsel as a result of King Charles III's reign. Today we remember our late Queen, her abiding commitment to her country, the realms and the Commonwealth, the values for which she stood firm, and the grace and dignity with which she reigned for more than 70 years. My Lady, 2022 was an eventful year for the judiciary and the legal profession. And as we look back on some of the highlights of that year, what better place to start than by recognizing Your Ladyship's historic appointment as Chief Justice, the very first Chief Justice, female Chief Justice of these islands, last October. Your appointment was warmly received throughout the islands in recognition of Your Ladyship's distinguished career, which includes your tenure as Chief Justice in the Turks and Caicos Islands, as well as before the magistrates and grand courts of these islands for several years. Please accept our warmest congratulations, my Lady, on this milestone. We wish you every success in your new role and are confident that your goal of establishing a blueprint for court excellence, to which you referred at your swearing-in ceremony last October, will be realized in very short order. Now, it's been said, my Lady, that every new beginning comes from some of the beginning's end. And so, as we welcomed our new Chief Justice, with some sadness we bade farewell to Your Ladyship's most esteemed predecessor, Sir Anthony Smellie KC, after his tenure of more than 24 years in that capacity. Now, the importance of Sir Anthony's contribution to the jurisprudence of these islands in all spheres of law simply cannot be overstated. And we look forward to the upcoming valedictory ceremony next week, where some of his many notable and indeed landmark judgments will be highlighted. To Sir Anthony, we again extend our very sincere thanks for his dedicated service over the years, our heartiest congratulations on the knighthood that was conferred on him last year, and our very best wishes on what can only be described as a well-deserved retirement from the bench. In yet another historic event, my lady, the islands welcomed the Judicial Committee of the Privy Council last November for its inaugural sitting, at which 3 appeals from this jurisdiction were heard in Courtroom 9, part of the new accommodation located in the former Scotiabank building, a building that we've heard much about in past openings. Some might say that that opening was itself a historic event, but the Privy Council's visit will long be remembered by practitioners and the wider public alike. And indeed, the opportunity to meet with our final appellate judges of these islands, some lawyers, including some very senior practitioners, noticeably starstruck, understandably, of course. Now, the completion of the new court facilities was long anticipated, and some will, of course, say long overdue. And without preempting your ladyship on this subject, I would simply observe that the amenities of the new Hall of Justice, as it is so fittingly known, are entirely consistent with the caliber of service delivered by the Cayman Islands judiciary, for which this jurisdiction is renowned. And now, my lady, I crave your indulgence to recognize some appointments in the past year. Firstly, that of Justice Ewan Kewley as a member of the Court of Appeal of Bermuda, and that appointment takes effect this month. Justice Kewley now joins Sir Anthony on the Court of Appeal, following the latter's reappointment in 2021 for a further term of 3 years. Our sincere congratulations to Justice Kewley on this very well-deserved appointment, and I dare say an appellate panel comprising Sir Anthony and Justice Kewley will be indeed a formidable panel. I also note the appointment of Court Administrator, Mrs. Suzanne Bothwell, as an acting magistrate. She has no doubt been a welcome addition to her fellow magistrates, and we wish her the very best in this new capacity. I would also extend congratulations to Acting Madam Justice Carter on this occasion, and wish her continued good work in the days ahead. I imagine there's going to be much more work to come. And finally, my lady, I'm pleased to extend a very warm welcome to Mr. Simon Davis, next to me, our new Director of Public Prosecutions. On this, his very first Grand Court opening. Mr. Davis took up his post in March of 2022, and we wish him every success in the days ahead. Turning now to legislative developments, my lady, in the past year. These have included the commencement of Parts 1 and 2 of the Legal Services Act, which provide for the establishment of the Council, as well as Sections 99 and 101. Now, the staggered approach to commencement was intended to allow for the administrative arrangements to be put in place, as well as regulations, fee structures, immigration requirements, operational procedures, and disciplinary rules. Full commencement is anticipated for the first quarter of 2023, and I'm pleased to report that the majority of council members have already been appointed. In Parliament's final meeting for 2022, the following legislation was among some of those enacted. A new Contempt of Court Act, which provides greater clarity as to those acts which constitute contempt and outline fair trial rights to which alleged contemners are entitled, in accordance with Section 7 of the Bill of Rights of the Cayman Islands Constitution Order 2009. The Criminal Justice Offenders Assisting Investigations and Prosecutions Act, which provides for the statutory codification of the use of King's evidence, and among other things, empowers the DPP to grant immunity from prosecution in certain cases, allows the court to make a sentence reduction on guilty pleas, and facilitates the review of sentences. We also saw passed the Identification Register Act and Related Identification Card Act, which collectively provide for a national identity scheme. These acts will not come into force until later in the year, however. We also noted amendments to the Anti-Corruption Act, which were approved. These designate the Anti-Corruption Commission as a law enforcement agency in the islands, confer additional powers on investigating officers, and clarify the circumstances in which the Commission shall investigate reports. Amendments were also enacted to the Customs and Border Control Act, my lady, and these relate to the procedures for asylum applications. Now, my lady, Parliament also approved the holding of a government-initiated referendum on the introduction of a national lottery, which will allow for the regulation control of an alternative activity and the decriminalization of cannabis. The referendum bill is expected to come before Parliament in the first quarter of this year. I now return, my lady, to the international standards for anti-money laundering, which I'll refer to as AML, and the combating of the financing of terrorism, which I refer to by CFT. My lady, at its plenary in Paris in October of last year, the FATF determined that the jurisdiction had satisfied the recommended action on beneficial ownership. This meant that the jurisdiction had satisfied 62 out of 63 recommended actions related to improving its AML and CFT regime, with just one outstanding recommended action left for completion. This now takes the jurisdiction one step closer to removal from the FATF's list of jurisdictions with AML and CFT deficiencies, and by extension, a step closer to removal from the EU's AML and CFT list. Please allow me, my lady, to commend both the public and private sectors for their tireless work to meeting the standards and actions to which the jurisdiction has been subject. It's not been an easy task, but it is eminently clear from these developments that their efforts have not been in vain. And for most of 2020, my lady, global headlines were and continue to be dominated by the invasion of Ukraine by Russia. And in response, over the course of the year, we saw the EU, the United States, the United Kingdom and Canada imposing further amendments to what have been described as unprecedented and some of the most severe sanctions against Russia. In April of 2022, government announced the establishment of a multi-agency task force comprising various government departments and statutory authorities to effectively implement our domestic sanctions regime, which is found under the Russian Sanctions Overseas Territories Order 2020, and in collaboration with the UK Office of Financial Sanctions Implementation, which is known as OFSI. As at mid-July 2022, assets valued at approximately US 8.4 billion and approximately 297.4 million euro had been frozen in this jurisdiction. And in the past year, there was a steady stream of license applications being made to the governor to allow applicants to undertake acts which would otherwise be prohibited under our sanctions regime. Some of these applications have raised complex and at times novel issues under the sanctions framework, and it is expected that the volume of work in this area will steadily increase this year. And following on from the UK's lead, my lady, the governor issued 2 general licenses, the first of which allows a relevant investment fund or fund manager to redeem, withdraw a deal with a non-designated person's interest, and make payment for routine fees, expenses from frozen accounts. The second such license, my lady, permits the supply or delivery by ship of Russian oil and oil products, as well as associated services, only where they've been purchased or sold at or below a corresponding price. This has been known as the Oil Price Cap General License, and work is currently underway for a 3rd general license, which is anticipated will be issued shortly. Now, these general licenses, my lady, similarly permit individuals or entities to undertake activities which would otherwise be prohibited under the OT's order, but without having to wait for a specific license to be issued. And given the ever-increasing number of new designations under the Russia sanctions, and more recently the Belarus regime, the likely corresponding increase in license applications, which I just mentioned, general licenses will offer more expeditious means of allowing certain actions to be taken, subject, of course, to compliance with certain conditions. My lady, from November 27th to the 1st of December last year, the Cayman Islands hosted the first in-person meeting of the CFATF since 2019. This event was attended by almost 300 overseas and 130 local delegates. And coincidentally, my lady, it was also the organization's 55th plenary meeting, the 30th anniversary of the CFATF as the first FATF-style regional body to be established. It was also the 3rd time that the Cayman Islands assumed chairmanship of the CFATF. Now, with such momentous milestones, the jurisdiction was understandably keen to deliver an unparalleled plenary experience for all delegates, and that it did with aplomb, through the collective efforts of various government agencies and public sector entities. And to those bodies, my lady, and their respective officers, I extend by the Police Service Commission, which was established in 2021. My congratulations to the appointees on their achievements. I also acknowledge the dedicated officers of our Customs and Border Control for their continued efforts to safeguard our borders. Finally, my lady, permit me to recognize
not mention it again. I'd like to congratulate the Attorney General's office and indeed the House of Parliament for passing an impressive raft of laws over the last year. I'm particularly interested, of course, in the Legal Professional Act, but also the Contempt of Court Act. Madam Attorney will recall that she and I had quite a long engagement considering how to proceed when the court of its own motion issued contempt proceedings under the existing legal professionals law against someone who was practicing law without a license. Practicing law, period, without being qualified. And so we wondered, we thought then that the Contempt of Court Act might have been useful to guide the court in terms of sentence, but also to guide the contempt law as to the process we must adopt and the protections that he was entitled to. So thank you very much for that. I now call on Mr. Simon Davis, the Director of Public Prosecutions, to second the motion.
My Lady Chief Justice, Honourable Judges of the Grand Court, Honourable Chief Magistrate, and other Honourable Magistrates, President of the Justices of the Peace Association, Honourable Acting Attorney General, Council Member of the Cayman Islands Legal Practitioners Association, special guests, distinguished colleagues at the public and private bars, ladies and gentlemen. I second the motion of the Honourable Acting Attorney General for the opening of this year's Grand Court. And I am grateful to my Lady Chief Justice for the opportunity to address the court and, in particular, to mention highlights of 2022, aspirations of the Office of the Director of Public Prosecutions in 2023, projects and plans to be executed, and also to comment on any initiatives to streamline the relationship which the office has with other stakeholders. First of all, I hark back to the speech which I made for you, my lady, on the day of your appointment to the position of Chief Justice. I mentioned then, and I repeat now, my commitment to work with you and with the judiciary in order to provide an effective and efficient criminal justice system. I would also like to mark the immense contribution of your predecessor, Sir Anthony Smellie. His long-lasting stamp on Cayman law will be felt for years to come. A more fulsome tribute will be given at his valedictory next week. However, for now, I would like to thank him for his dedicated service to this jurisdiction over many years and to wish him well in his deserved retirement. I would also echo the comments made by the Honourable Acting Attorney General regarding the service of His Excellency the Governor over the past 5 years, and also her comments in respect of Her Majesty the Queen and her passing. Turning to the highlights of 2022, the office of the ODPP, as I'll call it, has gone through significant change in the last 12 months. First of all, I wish to thank Miss Candia James Malcolm, my deputy, for her careful stewardship of the office before my appointment in March of last year. Secondly, I can report that 2022 was another busy year for the office. It received over 2,200 requests for charging decisions to be made. 104 indictments were prosecuted before the Grand Court, compared with 83 in 2021. While Crown Counsel prosecuted in the region of 1,200 cases before the Summary Court and 940 or so cases before the Traffic Court. Notable cases prosecuted successfully by the office include one for gross negligence manslaughter involving a collision between two boats, another for murder, which saw a minimum term sentence of 33 years being imposed, firearm and robbery offences in which double-figure sentences were imposed, together with convictions after the 12-week trial of 2 defendants involved in the CONCACAF fraud. Internally, the office saw 2 Crown Counsel departing to pastures new, while 3 Crown Counsel joined our ranks, 1 in traffic and 2 in crime. We've also recruited a full-time paralegal officer, and the senior management team is now well and truly established. This assists me in the effective management of the office. In April 2022, soon after my appointment, the office reflected on its direction, its values, and its approach. This culminated in the office firmly establishing its mission and vision statements afresh in May 2022. These statements will feature on our new website, which is due to launch in early February. Our mission and vision statements are founded upon strong core values and a realistic strategic approach. At the heart of that strategic approach are 2 concepts, namely our people. We put our people first, supporting their success and their well-being through development of their knowledge, skills, and commitment, so enabling them to thrive. And casework excellence, driving standards in the quality of casework through legal expertise across departmental agencies and international cooperation to keep the public safe. This strategy, as defined, is designed to ensure public confidence in the way we deal with victims, witnesses, and in upholding the rights of defendants in a clear, fair, and transparent way. In addition, the office now has its own mentorship scheme and well-being programme internally. although an independent office, it still invests seriously in government strategy, and its members should be proud of their recent engagement survey results. While I mention the members of the office, I pay tribute to my dedicated team, which comprises administrative support staff, my personal assistant, serious crime case manager, paralegal officer, a witness care officer, Crown Counsel, senior Crown Counsel, my 2 assistant deputies, and my deputy director, all of who play a crucial role in getting each case to court. I'm immensely proud of those Crown Counsel and other members of my staff, many of who will be closely involved with any given case, who often have to work way beyond their contractual hours in order to ensure that the prosecution of any case goes smoothly in court, especially so where cases continue to increase in complexity. Turning to our interaction with others in the criminal justice system, the office has welcomed engagement with Chief Magistrate Foldatz. Regular court users' meetings now occur at which relevant stakeholders, including our office, can provide feedback in order to further the smooth running of the summary and traffic court processes. Throughout 2022, Toyin Salako, Assistant Deputy, has been co-president of the ARIN Carib, that is, Asset Recovery Interagency Network, together with Detective Chief Inspector Richard Barrow of RSIPS. In November, together with RSIPS, the office hosted successfully a conference at the Kimpton Seafire Resort, at which 50 or so law enforcement delegates attended. The office was delighted at the end of that conference to be asked to hold the presidency once more in 2023. Throughout 2022, again led by Toyin Salako, members of the office have continued to assist the Honourable Attorney General and Cayman Islands government in responding to FATF compliance questions. This culminated in members of the office attending the recent CFATF plenary, also in November. And I echo the comments of the Honourable Acting Attorney General regarding that event. It will be a privilege and a pleasure for the office to continue to support the Honourable Attorney General and the Cayman Islands government during the course of the Honourable Attorney General's presidency of the CFATF this coming year. In addition, during 2022, the office has assisted the Honourable Attorney General with proposals relating to legislation. I won't go into all of those proposals. I'll mention key highlights involving the Anti-Corruption Amendment Act, the Proceeds of Crime Amendment Order, which now treats certain gambling offences as lifestyle offences for confiscation proceedings, and the Traffic Amendment Act, which lowered the limits for drink driving cases. Turning to aspirations, projects and plans for the Office of the Director of Public Prosecutions. For 2023, the Office has a number of ongoing aspirations, projects and plans. And when considering our overall vision for the future, our people are at the heart of that. And the strategic approach of the Office involves putting our people at the heart of what we do. This involves ensuring that the right office culture and ensuring the right work-life balance for those who work tirelessly as they prepare and prosecute cases in court. This approach will continue, not just for 2023, but beyond. Casework excellence and professional standards and the strategic approach of the office also involves driving professional standards upwards. This involves building upon all of the hard work implemented by the senior management team last year, for which I give thanks, with regard to regular training and development, regular appraisals of staff and counsel, and regular monitoring of the work of our Crown Counsel to ensure that cases are prosecuted to a high standard. In particular, the training and development programme put in place by my deputy, Ms. Candia James Malcolm, should provide all continuing professional development needs of new and established practitioners as they receive monthly training sessions and access to a state-of-the-art online resource facility which has been established. Digital capability and strong relationships are the other aspects of our strategic approach and involve ongoing projects for 2023. The website. For the past 4 months, the office has been designing and building its new website. Amongst other things, this will provide much needed information to the public, especially to do with criminal procedure and victim and witness care. It will assist with transparency and will also provide necessary information for those making requests to the office from overseas. The website should be up and running in February 2023. Computerization, and with the assistance of Dan Hayden and other members of the CIG Computer Services Department, the office is going digital. This involves a number of key aspects. Firstly, the office is expanding its digital case management system. Secondly, it involves all Crown Counsel leaving paper behind and presenting cases in court using laptops. This is as the court indicates its intention to enter the digital arena for case management and trial purposes. Thirdly, the office hopes for digital, I use the word hope, the office hopes for digital integration to some greater or lesser degree with, in particular, the office communicating with the court and RCIPs through APIs, application programming interfaces. I won't get into the technology, but apparently they work. The office will make any necessary arrangements to facilitate this process. And fourthly, it involves digital archiving of finished files with obvious cost and space savings. Moving on, with a careful eye to the future, the office has successfully recruited 3 new Crown Counsel who are due to commence their employment with us over the coming weeks. The office also has ongoing recruitment exercises for Senior Crown Counsel International to assist with the increase in overseas requests, fraud and financial crime offences, together with our FATF obligations. A second witness care officer in order for the office to fulfil its obligations under our witness charter and in particular in respect of summary court obligations, and a case progression officer to ensure that communication between the office and the court and with other court stakeholders is more efficient and effective. Further, the office welcomes the recent practice direction which relates to custody time limits, CTLs. Our updated internal rostering process enables the office to manage trials being accommodated within the recognised custody time limits. The office also welcomes the arrival of the Legal Services Act and the consequent establishment of the Legal Services Council, and as and when required to do so, the office will be happy to assist the council as it develops. In accordance with our strategic approach, the office looks forward to strengthening its relationships with our key criminal justice system partners over the coming year. Finally, I echo the exact words of the Honourable Acting Attorney General in wishing a safe, prosperous and productive new year to your ladyship, all judges and magistrates, the court staff, fellow members of the legal profession and those who attend today. My lady.
Thank you very much, Mr. DPP. I am not allowed to forget your affection for acronyms. RCIPs, when we first met, I had to ask you what that was. And today, APIs and CTLs. Very modern of you. I will continue to have to spell out words, just I will have to continue to use paper on this bench to make my presentations. I know where we're going, but we're not all going to get there. Congratulations on becoming so digital that your counsel are able to present cases using, what was it? iPads? Good for them. I
Milady,
will not be writing my judgments on any such thing.
Milady,
But
can I say,
you're right. I think it's the right direction.
Milady, not yet. CBC have something to do with the
CBC.
laptops arriving. Customs and Border Control.
Oh, thank you.
I'm trying to get them through customs.
Well, congratulations anyway, and congratulations on concluding what must have been an exciting strategic planning exercise where you renewed your mission and vision statements. And I commend you on your strategic approach, which is to put your people first. It is the only approach in anything we do, whether it's the people that we work with or the people that we serve. So if you can put them all first and still win, then you're ahead of the game. Thank you very, very much for your presentation. I'm going to refer to the figures, the prosecution figures for criminal matters in the jurisdiction in my speech, and have something to say about what you have said. Thank you very much, Mr. Davis. And I now call on Mr. Barton, who I understand is speaking on behalf of Super President Eric Barton, or was there an election of which I'm unaware?
The former position is correct, lady.
All right.
And I can assure you, this pattern is not deliberate. Having said so, Mr. Borden offers his apologies for his unavoidable absence, and I have been asked to deliver this speech on his behalf. My Lady Chief Justice, honorable judges of the Grand Court, honorable Chief Magistrate, honorable magistrates, honorable Acting Attorney General, His Excellency the Governor, the Honorable Deputy Premier, my colleagues at the bar, our special and distinguished guests, ladies and gentlemen. If it may please my lady, I have had the great honor of supporting the motion to open the Grand Court for the year of 2023 and making this speech on behalf of the Cayman Islands Legal Practitioners Association. As is customary, the SILPA President's Grand Court opening speech is used to raise awareness of SILPA's work over the past year and to highlight upcoming projects, challenges that we will no doubt face in the upcoming year. I am pleased to report that SILPA continues to move from strength to strength following the merger of the Cayman Islands Law Society and the Caymanian Bar Association. It now boasts over 600 members representing almost 70% of the legal profession. And although we faced many challenges this past year, SILPA has also made great progress with various initiatives advanced by the Council. From its inception, SILPA was primarily focused on two main pieces of legal industry reform: the Cayman Attorneys Regulatory Authority, CARA, and the Legal Services Act. This work will no doubt continue into 2022. CARA, now in its fourth year of operation, continues to successfully act as the AML supervisor for the attorneys in the Cayman Islands, with an exceptionally high caliber staff overseen by a board of non-lawyers, ensuring its independence from practicing attorneys who are subject to supervision. SILPA is extremely grateful for all the work done by CARA, the board of CARA, and the SILPA CFATIF committee. I should also take this opportunity to thank the government for its continued support of CARA, and in particular, the Financial Services Ministry and the Office of the Honorable Attorney General's Chambers. Of course, my lady, no Grand Court opening speech would be complete without mention of the Legal Services Act, which was passed by the Cayman Islands Parliament in late 2020, signaling the legal industry formal acceptance of the need for legal services reform for over some 50 years. The Legal Services Act is essential to ensure that the Cayman Islands is able to maintain its position as the preeminent jurisdiction for financial services. It introduces a formal code of conduct and modernizes the regulation of attorneys practicing Cayman law, both within the islands, whether as sole practitioners, members of firms, or as members of affiliate firms practicing outside the jurisdiction. It also provides a framework for the training, development, and progression of Caymanian attorneys, which is critical to the success of our legal services industry, but more specifically to the financial services industry. Although the LSA had been passed in 2020, I was unfortunately still unable to confirm at the time of last year's Grand Court opening that the Act had actually been commenced. Council's primary focus at the outset of 2022 was to continue its work with the government on the commencement of the LSA and a promulgation of the regulations. My lady, I feel extremely proud to report at this Grand Court opening that parts 1 and 2, as well as sections 99 and 101 of the Legal Services Act were finally commenced and made effective on the 14th of October, 2022. In December 2022, the first sets of appointments to the new Legal Services Council were made. We can also now look forward towards the commencement of the remaining parts of the LSA within the next few months and finally move on to the next phase of the evolution of the Cayman Islands legal services industry. Mr. Deputy Premier. There was also various other important legislations passed or commenced over the last year, which involves a great deal of work by various SILPA members, along with, amongst others, the Ministry of the Financial Services. Of particular note was the Companies Act Part 5 reform, introducing the new restructuring officer regime in the Cayman Islands, which took a Herculean effort by many attorneys, accountants, members of the judiciary, and government. My lady, moving on to training and education, SILPA continues to play a vital, important role in the training of law students and attorneys in the jurisdiction. We work closely with the Truman Borden Law School generally, but also as a part of the Legal Advisory Council, chaired by Your Lady, which is responsible for setting standards for legal education and practical training leading to the local qualification and enrollment as an attorney in the Cayman Islands. In furthering this mandate in 2022, SILPA formed a Cayman Islands Foundation jointly with the judiciary and the judicial administration called the Cayman Islands Judicial and Legal Education Institute, which my lady will be grateful to know we have just classified as the foundation. No acronyms there. The intention for this foundation is to run as a centralized platform for legal and judicial education in the Cayman Islands, covering a wide variety of programs throughout the year, including, my lady, advocacy workshops and the current judicial clerkship program. It is also hoped that the foundation will play an essential role in the regulation and provision of the continuing professional development and legal education requirement anticipated to impact all attorneys following the commencement of the remaining parts of the LSA. I am pleased also to report, as foreshadowed in my last opening speech, that SILPA was able to successfully launch the SILPA Seminar Series in 2022 and will continue this series this year. Many thanks to the SILPA Education Subcommittee for all their hard work in getting the program up and running once again after the COVID interference. The first session was jointly run with AMA, titled Cayman Sanctions, The Basics and Beyond, and was held at the Commander Bay Cinema. The second was run jointly by CEPA and covered the new Cayman Islands Restructuring Officer regime. Both of these sessions were followed by a networking event, again furthering our initiative to help connect members of SILPA with members of other local legal industry-related associations. Another 2022 initiative that SILPA worked on along with the Truman Borden Law School and the Department of Legal Aid was the development of the first ever Cayman Islands Legal Assistance Clinic, which formally launched in May 2022. Throughout the clinic, students and attorneys provide advice on civil claims up to $20,000, as well as on criminal, traffic, and family matters. A great deal of effort was put into making this happen, in particular by Mr. Andrew Perkins of the law school and Ms. Darlene Oko, legal counsel in government. We hope that the clinic will provide greater access to justice for eligible members of the community through the provision of pro bono legal advice and assistance, and serve as an excellent training and education experience for students that participate alongside the qualified attorneys providing the advice. We are also pleased to announce the formation of the Criminal Bar Subcommittee, chaired by Mr. Richard Barton, with Mr. Benjamin Tonner KC, and Ms. Prathna Bodden as committee members. We are excited for this development and hope that this will bring added value to the criminal defense bar. My lady, in terms of bereavement, we wish to acknowledge the unfortunate passing of Mr. Keith Collins, who was a prominent member of the criminal defense bar and will be greatly missed by the legal fraternity and all those that knew him personally. Before I close, I would like to mention two further events that took place during the course of 2022, which outside the commencement of the LSA were possibly the most important for the legal industry. The first was the appointment of your ladyship as the new and first female Chief Justice of the Cayman Islands, taking over from Sir Anthony Smelly KC, who held the position for over 24 years. I personally had the distinct honor and pleasure of working with Sir Anthony over the past 5 years on the Legal Advisory Council and various other SILPA initiatives. On behalf of the legal industry, we thank Sir Anthony for his service and his dedication and wish him all the best in his retirement, and of course, your ladyship and all the success in your new role. The second, my lady, was the attendance of the Judicial Committee of the Privy Council to the Cayman Islands, which was probably the most significant event to occur within the legal industry since the establishment of our very own court system. For 1 week, members of the public were able to witness firsthand our final appellate court right here in the Cayman Islands. The week ended with a gala that was hosted jointly by the courts and SILPA, which by all accounts was a great success. We look forward to welcoming the Privy Council back to the Cayman Islands soon. In closing, I would like to thank my current fellow council members, Vice President and Secretary, Mr. Nick Bullmore, Treasurer Mr. Justin Hart, Ms. Wanda Ebanks, Ms. Kendra Foster, Mr. Klein Glidden, and Mr. Richard Barton for giving up so much of their personal time outside of their very own heavy work commitments to support SILPA and all of its initiatives. It only remains, my lady, for me to formally second the Honorable Attorney General's motion to open the Grand Court for the year of 2023 and to take this opportunity to wish your ladyship, judges, court staff, and fellow members of the legal profession a happy and prosperous new year.
Thank you, Mr. Barton.
Indeed,
Might I say, I welcome the news of this Criminal Bar Association. It is high time we had a body which could represent the views of criminal advocates, because your concerns are very different from, let me say, the chamber-type lawyers who dominate in numbers in the jurisdiction. And we often don't have a central body with whom we can communicate about issues that arise in the criminal divisions, which are such important divisions of the courts. I'm very pleased. And at least we've mentioned the Legal Services Act, finally, as concluded and no longer aspirational. And maybe after this year we won't have to mention it at all. I think we'll all be very pleased with that. I'm excited about the training initiatives to be undertaken by the Judicial and Legal Educational Foundation. There's my brother, Kaylee. And congratulations on your series. And yes, I think the Legal Assistance Clinic is a feather in all our caps. And I see the director of the law school hiding in the back of the court. Forgive me for not recognizing you sooner. And from whom I'm sure we will one day have a report on the efficacy of that project. Thank you for mentioning the JCPC. That's another 300 words out of my speech. It was indeed momentous, historic. It was amazing. I was, Madam Attorney, starstruck. It wasn't just the bar. And thank you for mentioning that. It was indeed one of the high points of last year. Thank you, Mr. Barton. I now call on Mr. Colin McKee.
My lady, I'm very much obliged. It would be remiss if I did not acknowledge
Yes.
the Honorable Chief Magistrate who, through the Court Users Committee
Yes.
that my learned friend Mr. Davis mentioned, recommended the formulation of a subcommittee by virtue of SILPA, resulting in the Criminal Defense Bar Subcommittee. So I want to
Quite-
personally acknowledge Mr.
right.
Valdez Folas for his...
Well, I'm going to give him all the credit then for the work you've done. Quite
Very
right,
good.
Chief Magistrate,
I'm obliged, my lady. May it please you.
for seeing the lacuna and advising the council to fill it. Mr. McKee.
Protocol having already been established by the prior speakers. If it may please my Lady Chief Justice, I am privileged to be able to support the motion to open the Grand Court for the year 2023, moved by Madam Attorney and seconded by Mr. Director and the President of the Cayman Islands Legal Practitioners Association, and to provide these brief remarks with the minimum use of acronyms. It would be remiss of me not to take this opportunity to pay tribute to Sir Anthony Smelly's contribution to our jurisprudence. From his elevation to the bench on the 11th of October 1993 to the end of the most recent 2021 volume of the Cayman Islands Law Reports, 405 of Sir Anthony's judgments have been reported. That number will no doubt continue to grow until the law reports have published judgments up to and including the 25th of October 2022, when Sir Anthony demitted office. In addition to those reported judgments, there are many more judgments that were not reported. I do not have those figures, not least because Sir Anthony had been on the bench for over 8 years before I became a consulting editor to the law reports. Nevertheless, I would hazard that the number of his unreported judgments is measured in the many thousands. A full appreciation of the learning and wisdom of Sir Anthony's judgments must await another more appropriate occasion. But it is fair to say that they shine with his intellect, learning, wisdom, and experience. Speaking as Secretary of the Grand Court Rules Committee, and noting my predecessor on my left, the Honourable Andrew Jones, King's Counsel, and therefore thus strictly beyond the remit of the law reports, I also wish to take this opportunity to recognise Sir Anthony's chairmanship of the Grand Court Rules Committee. He has brought great energy, experience and foresight into the drafting of rules, practices and procedures across all aspects of the work of the Grand Court. Time today does not afford me the opportunity to give a proper account of Sir Anthony's tireless work on this essential aspect of the office of Chief Justice. As my lady is aware, the preparation and publication of our law reports in 2020 and 2021 was much delayed. No one will be surprised to know that the fundamental reason for those delays was COVID, my first and only acronym, which impacted upon every stage of the review, editing, preparation, printing, publication, and dispatch of the law reports. In 2022, everyone concerned in those processes made great efforts to clear the backlog. Although substantially cleared, publication of our reports in 2022 was still not as timely as it had been the case prior to the onset of COVID. Nevertheless, absent any unforeseen circumstances, the editors are confident that by the end of this year, publication timetables will be restored to that which prevailed in 2019 and earlier years. Our courts delivered 205 judgments in 2022. They may be broken down as follows. In the Grand Court, Financial Services Division, 112 judgments. In the Civil Division, 39. In the Criminal Division, including appeals from the Summary Court, 24. And the Family Division, 8. In the Court of Appeal, there were 20 judgments. and in the Privy Council too. All judgments are, of course, available on the judicial website. We understand from the administrator that the judicial website is undergoing renewal and improvement, which changes will no doubt facilitate the ready access to judgments. We thank you and the judges of the Grand Court, the President of the Court of Appeal and the Justices of Appeal, the Chief Magistrate and the magistrates, for your unceasing dedication to administer justice in these islands independently, fairly and efficiently. Much of that involves long hours outside of court, such as preparing for hearings, writing judgments, and ensuring the efficient administration of our courts. I wish to express our thanks to those people, based here and overseas, who have willingly given up their valuable time in 2022 to sit as acting judges of the Grand Court and as acting magistrates. In the Grand Court, the acting judges comprised Marlene Carter, His Honour Roger Chappell, Eileen Downey, the Honourable Martha MacDonald Bishop, the Honourable Robin Macmillan, Tim Owen, King's Counsel, the Honourable Dale Palmer, Simon Russell Flint, King's Counsel, Philip St. John Stevens, David Southey, King's Counsel, Alistair Walters, the Honourable Frank Williams, and Michael Wood, King's Counsel. In the summary court, the acting magistrates comprised Suzanne Bothwell, Robert Jones, David McGrath, and Adam Roberts. We also wish to express our gratitude to the administrator, the clerk of the court and her deputies, and all the administrative, technical, security and support staff at the courthouse who, behind the scenes, work hard and diligently to assist and serve the public and the attorneys. It now only remains for me to wish a happy, healthy and prosperous new year to you and all of our judges, magistrates and clerks, to the entire administrative staff, to all members of the profession, and to the people of the Cayman Islands. I have the honour and privilege to support Madam Attorney's motion this morning.
Thank you, Mr. McKee. And might I just say that the former Chief Justice's energy, experience and foresight didn't just apply to his work on the Rules Committee, but in almost every aspect of his remit as Chief. You have said you don't have much time today, but of course you know that there will be a valedictory next week, and I expect we will take up more than the hour allotted. Where's my brother who is organizing the conference? More than the hour allotted in order to sing Sir Anthony's praises. If we're late for the conference, it is all the same, because he's being celebrated in both. A little bit more on that after, but thank you for giving us the numbers of judgments reported. It doesn't paint the whole picture of the work of the courts. To say 8 family judgments were rendered might leave people with the false impression that that court is not performing. And so I'll have something to say in my contribution about that and the blueprint for excellence and our intention to capture data to make what used to be called, what was it, lies, damned lies and statistics, to make
Thomas
them
Carlyle.
actually make sense and be useful, and not something that we manipulate, but that we really have the data. Now, when we say 8 family cases, we can move on to say, at the same time, there were 359 cases in that division. 66 of them were resolved in mediation. Another 100 of them were simply resolved by the court outside of mediation, leaving only 8 to be tried. Put that way, the work of the family division is more impressive, isn't it? And so we are going to be embarking upon this program of excellence, at the heart of which is performance measurement, so that when we speak about work done, it is in a context that can inform our decisions yours as a publisher of our reports, us as the persons who must provide court staff and judges to try matters and inform the public who are the users of our services, the public and the bar. So thank you very much as ever for your contribution, Mr. McKee. All right, well, I declare the court open. And might I just suggest to my colleagues who sit below that they use Google Word Count too. So it's a very good guide as to how long your speech actually is. I have 11:25, and I'm going to be very frank and say this to persons who would ordinarily expect to be recognized or have a personal mention on this occasion. You're all in my written speech. And so if I don't mention names as I go along, it's not because we haven't remembered you. It's simply in the interest of time. That said, I'm starting with Sir Anthony. And I'm not going to say that he's in my speech. And I'm going to reiterate that, well, I said my farewells when I was being sworn in. What you don't know is that that day, when I was sworn in the public, was supposed to be Sir Anthony's valedictory. And he gave it up for me. And so I'm very, very pleased that we're able to have his valedictory ceremony on Monday the 16th. It will start at 2, finish at 3 in time for my brother's conference, which begins at 3:15. The valedictory is to celebrate his work, and then the conference is actually to examine in greater detail some of those 450 cases that Mr. McKee just mentioned. We could be here all night. We'll have to be very selective. My contribution to that is already well in excess of 25 pages, and I need to do another Google search. So I trust that you have all received your invitations. This is not the usual turnout at the opening. I know we're being live streamed, so I'm saying this to those who are watching, that please join us for both the valedictory and for the conference, which has been organized by my brothers K. William Cedar. We look forward to seeing you there. There are a few farewells that I have to make because these persons have served too long and too faithfully for me to say your names are in my report. We said farewell last year to the court's law librarian, Mrs. Beverly Spears, who retired in May 2022. Miss Bev, as she was fondly known, was also the librarian for the office of the DPP, the Attorney General's office, and the law school. And she did this for many years. According to our records, Miss Bev served us in the courts for over 19. And that's extraordinary when you consider that working in the law libraries was her second career. And that before that, Miss Bev had been the librarian to our public schools. So she has lived a life of service, providing extraordinary service to the public schools and to the courts and the other legal departments. So and she managed all of those 4 agencies, us and the offices of the DPP, etc., with great aplomb. She was never at a loss, and we really thank her for her service. And on that note, I take the opportunity to welcome our new librarian, Victor Valerian. I'm sure I've gotten that wrong, Victor, and I do apologize. But who is proving to be a very worthy successor and has gotten us a whole slew of books in a digital format. So I'm going to be forced to learn to do research digitally. And so congrats to Mr. Victor for that. We also lost, when I say lost, that sounds bad, Mr. Claude J.R. Douglas also retired. He was, I think, better known as a musician and in the J.R. band than he was as a marshal of the court. But we used that strength of his too, because for many, many years, up until his retirement, J.R. was our resident sound man for the Grand Court opening, and he managed all the court's audio needs. So we thank him for his support of the judiciary over his many years of service. In 2022, we also said goodbye to Mrs. Patricia Palmer, who was a personal assistant to the Chief Justice for some 16 years before she transitioned to a new post of Judicial Affairs Administrative Manager in 2021. That post has responsibility for the arrangements, for the rosters, for the temporary judges that you've heard Mr. McKee speak of. These are judges. I depart from the Chief Justice in this. I prefer to refer to them as a supplementary panel because they augment the capacity of the court when we need it and provide specialist skills when those are needed as well. So Ms. Pat did that in her last year before taking her retirement. And we thank Ms. Palmer for her years of dedicated service to Sir Anthony, as well as these other members of the judiciary for whom she was responsible. We wish her well in her retirement, and I take this opportunity to formally welcome her replacement, Ms. Renee Shortridge. A number of employees in the organization competed for new posts and won them. These are not promotions per se, because we don't have the power to promote, but they were all, for each of these employees, upward transition and to be commended because it was in the course of open competition for new posts. I'm not going to mention them. They know who they are, and they're in my speech. We also welcome 17 new hires. Again, I cannot list them all, but I'm especially pleased by the recruitment of an additional court reporter. This is important not only to address the current backlog in court reporting, and I say that without any criticism of the court reporting staff. There's only so much you can do with so many people. But having the new court reporter will allow my sister Richards to have 3 criminal courts sitting in April. And she tells me that they're very important sittings. 2 matters are murders and one a child rape. And so it's important to be able to accommodate these particular matters when the child victim is not in school and can be accommodated by the court. As my colleagues below have mentioned all the milestones of 2022, the JCPC visit, and I think I should just mention that, the justices presided, as young Barton mentioned, in the 2 new courtrooms. We're very pleased to have been able to bring those courtrooms online last year. It has, these are in the lower courts on the Cardinal Avenue. It has given us a welcome increase in capacity, particularly in circumstances where one court will be assigned to the Court of Appeal. In years past, whenever the Court of Appeal was here, they took over a courtroom which was otherwise being used, and so one court had to cease sitting for that session. That will no longer happen. They can now work on endlessly whether or not the Court of Appeal is here. And I'm speaking primarily to the magistrates who would often suffer a loss of court space. There are loads of people to thank for bringing that project to fruition. Again, I cannot mention them each, but they're in my speech. We have some IT infrastructure landmarks. Mr. DPP, you'll be pleased to know that we are working line on line with you and the other agencies to improve our digital platforms. I think, and I'm sure she will be bold enough to stand up and correct me, the clerk says that we have completed the final rollout of the Curia Apex case management platform within the FSD, the Civil Registry, and the Civil Division. So perhaps that started off sounding really good. We've only completed it in 3 divisions, and there's much, much more work to do. But the platform allows us to disseminate rulings, orders, judgments, and applications. And the streamlining of these documents within the platform is another milestone in the journey started by Sir Anthony to becoming a paperless court. Attorneys and notaries are now able to pay for their practicing fees and notary renewals on our online portal. We are all over any initiative which allows us to collect money more efficiently. And so attorneys, you can now pay online. We also have the capability, offer the capability to self-represented litigants, police officers, and other justice sector agencies to have online access to courts' offices, to file court documents without having to commute to the court building. So once they're registered on the website as a user, they can use the eFolio portal to file. As I said, we are testing an e-payment component of the Curio platform, and we're currently exploring, and Justice Doyle, I didn't take it from his website, but we did come up with the idea of kiosks. When I checked David Doyle's website, Mr. Justice Doyle, who was then First Deemster, a very attractive name for Chief Justice. When he was First Deemster in the Isle of Man, I think they had 25 kiosks where you could pay fines, baby money, that's maintenance, and other court fees. And I think this is a way to go. I'd like to have a ATM sort of kiosk outside every library, maybe every bar. I am not going to choose locations wherever I think people might be. Right? Yeah, before they spend the money. And so we're working on not just the online platform to improve payments but thinking outside the box. Well, how outside the box is it if it's already being done in the Isle of Man? But thinking of introducing things like the kiosk so we can better collect the money due to, I don't say to us, but simply the money due for court payments. I have to tell you something else because it's really exciting news. Well, I think it is. I don't know how the public will regard it. If they think we've suddenly become quite threatening, and I'll explain that to you. The issue of adequate court security has been a topic of concern for years. And with the support of the Commissioner of Police, and you will tell him, DC Kurt, that we mentioned this today, with the full support of the Commissioner of Police, Mr. Derek Berg, and the government, we now have a formally established court protective unit. It operates under the auspices of the Royal Cayman, RCIPS. It operates under the aegis of the Royal Cayman Islands Police Service. It comprises 14 auxiliary officers, and there's a sergeant to be appointed later this year. And this means that in 2023, court security will largely comprise uniformed auxiliary officers. That's why I said I'm not sure how the public will receive this, because there will be police with red seams at every point of the court. But for me, this is not only is the existence of the auxiliary force welcome, but the fact that they have that show of force, that they're in full uniform, that already wins half the security game. Just being visibly on the court premises in uniform, it's a great advantage. But that is not all. Of course, they're completely and fully trained officers. So they will understand how to effect powers of arrest. Sometimes we do have to arrest people at the court compound, it's rare. And how to maintain law and order within the courts. And now we have 9 open courtrooms. That's a good number. We now have 9 open courts. We have other rooms that operate as chambers, which judges can choose to use as open courts. And now we have so many, we do need a professional staff to ensure the safety not just of the judicial officers, but of all the persons who come and use the court. That's 15 minutes. Now, I want to tell you about my plans. Madam Attorney, you mentioned the Blueprint for Excellence. We have 2 objectives for 2023, the first of which is to establish a blueprint for excellence, for court excellence, and I had promised to, at my swearing-in, to elaborate more on this, and I'm going to do this now. I hesitated, because I thought you might all feel that you had a very long lecture and not distracted by PowerPoint. I almost introduced a PowerPoint into the open because I don't want to lose your interest. So bear with me while I sketch out for you this blueprint for excellence, because this is the last time I'm going to discuss it publicly, although we will have intensive meetings on it privately with our staff, our stakeholders, and court users. It is the judiciary's intention to implement what is called the International Framework for Court Excellence. I'm going to refer to it hereinafter as the framework. The blueprint for excellence will inform the strategic planning exercise on which the court will embark in March of this year. It is my view that the results of implementing the framework will inform us of the areas of the courts where we are performing under par and give us the tools we need to drive performance forward. I mentioned at my swearing in, I don't like making decisions shooting from the hip. I think in today's world, when we have the facility of capturing data, we should use the data to inform our decision making. Now, the framework was designed by an international consortium for court excellence. It includes the National Center for State Courts, among others. You may not know this, but it was a research done by the National Center for State Courts that prompted us to introduce the drug court. That and our experience of our friend in Canada, I can't remember his name, his experience of the drug courts in Canada. This is data-driven justice. Nobody decided to do a drug court because they thought it would be a good idea. When we introduced it, there was a lot of data that justified its establishment. And I think, if I recall, a few years ago, our local drug court was actually evaluated by an external agency. I think it was the National Drug, what do they call it, NDC. That's an acronym. And I can't remember what the C stands for.
Council.
That's the one, National Drug Council. There you have me, Mr. DPP. And I think it got very good marks. And this is what we want. We want to establish programs which can be internally or externally evaluated so we know where we are. Now, the framework is not complex, but it is a lot of information to condense on an occasion like this. And I do run the risk of losing your interest or overwhelming you, but just ask you again to bear with me. The framework is a quality management, not assurance, Mr. Harris, quality management system. I did see your report in the press. It is a quality management system designed to help courts improve performance. It is built on 10 core judicial values. Those are equality before the law, fairness, impartiality, independence of decision-making, competence, integrity, transparency, accessibility, timeliness, and certainty. These are universal core values for judges. The framework identifies 7 areas of court excellence which are aligned with those values. The 7 areas of court excellence are these. 1, court leadership and management. To provide organizational leadership that promotes a proactive and professional management culture, pursues innovation, and is accountable and open. Court planning and policies. To formulate, implement, and review plans and policies that focus on achieving the court's purpose and improving the quality of performance. 3, court proceedings. To ensure the court's proceedings and dispute resolution services are fair, effective, and efficient. Public trust and confidence. To maintain and reinforce public trust and confidence in the court and the administration of justice. 5, user satisfaction. That's something we don't ever ask. User satisfaction, to understand and take into account the needs and perceptions of the court users relating to the court's purpose. 6, court resources, and this will speak to the government, to manage the court's human, material, and financial resources properly, effectively, and with the aim of gaining the best value. 7, affordable and accessible services, to provide practical and affordable access to information, court processes, and service. The last aspect of the framework are the global measures of excellence. And just like the core values, the global measures of excellence speak for themselves. The use of the global measures is because what the framework really is a methodology for assessing the court's performance against those 7 areas of excellence. And it provides clear guidance for the courts as to who intend to improve their performance. What the ICFE framework says is this: a foundation stone of excellent court planning and performance is a maintenance of accurate, comprehensive, and reliable information and databases. And when I'm finished with this, I'm going to come back to Mr. McKee and to Mr. Davis on their record of cases done, judgments handed down, and the court's own records, because there was no mesh. In fact, we were so far apart, I had to consult with my sister Richards on the numbers of work going out of the court. We know the numbers coming in because everything is registered. What we're not recording with any great efficiency is, I see the Chief Magistrate agreeing with me, what we're not recording with equal efficiency is the work that's being produced. So as the framework says, maintenance of accurate, comprehensive, reliable information and databases is essential to assessing the performance of a court. It's also essential to assessing whether the strategies, the activities that we have selected for improvement are having effect. 11. There are 11 global measures. When I run through them, stay with me, or next year I will bring the PowerPoint. Court user satisfaction. That's the percent of court users who believe that the court provides procedural justice. Now, if you listen to the blogs, you read the blogs, you listen to some of our media houses, there's a lot of court users who don't believe that there's procedural justice, i.e., accessibility, fairness, accuracy, timeliness, knowledgeable players, both on your side and on mine, or courteous judicial services. So this is one of the things that they measure: court user satisfaction, access fees, the average fees paid in civil cases, case clearance rate. That's one that everybody is familiar with. It's the number of outgoing cases as a proportion of the number of incoming cases. On-time case processing, the percentage of cases disposed of or otherwise resolved within established timeframes. Duration of pretrial custody. We now have custody time limits. The average time between the time defendant has been detained and when his case is concluded. Court file integrity, that's a percentage of case files that can be located and retrieved in a timely manner, and files that meet established standards of accuracy, organization, and completeness. We've all had files missing affidavits or certain documents. Case backlog, that needs no explanation. Trial date certainty, that's when I tell you to come on January 16th for your trial and you come, you are tried. Employee engagement. The employees in the organization, and I'm not carrying any brief for them, but I think they have felt, among all persons within the court, the least engaged. Now we're going to have, this whole process starts with a survey. And the survey is administered by the court, and it asks questions. Let me see if I can find one of the questions. It asks questions like, do you think your leadership has been innovative and inclusive? And the answer could be anything from, I don't understand, to innovative, and anything in between. Now what happens is that you have a score. you score each of these answers 0 to 5, and you produce a result which is going to guide the strategic planning process. Having administered this questionnaire, we will know where we are falling below the optimum performance standards and where we are performing at those standards. I'm just saying I suspect that the questions that ask our employees, our staff, whether they are included in this decision-making process, whether they understand the work that we do, I'm concerned that we're not going to get a high score. And for me, because we will all, this is a collaborative process, we will all have an opportunity to say which of the measures we are going to pursue first. You don't have to pursue all 11 measures the same day. Measure 10 was compliance with court orders. I know the court administrator has been her bonnet, if I may say, about people not complying with court orders, particularly in maintenance. She thinks court orders are made to be obeyed, and especially in the case of women, that the money must be collected. And the last one, and some of you might remember this from the Auditor General's report, something called cost per case. So that's 11 measures. We will all have the one that we want to advance. Me, I would like to start with the employee engagement. This is it's similar to your engagement survey, DG, but directed primarily at the court staff. Others will want to consider cost per case. I should think that any administrator would be concerned with identifying that cost, the cost to the court of trying each case. So there's a lot of work to do, but this will inform our strategic planning, which will start very quickly. As soon as we can complete the questionnaire, then we will know what areas we want to focus on. Those of you who've done strategic planning will understand SWOT analysis. So the questionnaire will let us know where our strengths are, where our weaknesses are, identify opportunities and threats. Using the framework's guidance, we won't need to be finding our own targets. The framework provides the targets for us. I'm excited, and I'm excited to work collaboratively with all court users and stakeholders, and that includes the police, the prison, who is not here today, but hopefully they will attend when we come to make the internal presentation. It will include government departments such as DCFS, counseling. It will include the HSA, because that is for our mental health clients, as well as the children who have drug abuse issues, who should never be in a criminal or non-therapeutic setting. We'll also collaborate with the GLSE. It is my intention to have a greater collaboration with the GLSE throughout my tenure. It's currently an enormous resource. The chairman himself is a business leader who trains innovative leadership. And we have Miss Bridget, who runs a family company which is known for its customer service. So right there within the JLSC, we already have an extraordinary talent. Our JLSC has on it the president of the Caribbean Court of Justice, which is the only Caribbean court to be admitted into the international consortium or accepted by the international consortium as a court of excellence. And so we have Adrian Saunders there as a resource. Our friend next door, Chief Justice Brian Sykes, he is, I think, 3 years or 4 years into his own Court of Excellence plan. Can't remember what he called his. But he is 3 or 4 years in and has a statistician now on staff in order to capture the data to inform this process. I have the DG here, and he's already told me that the resources that I need are already within the government. We will see if that's true. But I'm going to use all the resources he does have. But I will tell you that the National Center for State Courts will assist in the process. When you read the paper, the strategic plan for the Jamaican courts, right there on the list it was a representative of the National State Court, so we're not going to be alone. We will have loads of help, both from within and externally, from the DG and from the state courts. You know, Singapore, the Singapore State Court is one of the founding members of this international consortium. The World Bank has keeps a data of different things. And in this section called Rule of Law, Singapore has a rating of 95. I don't know if this is the occasion to share that on that same data, World Bank data, we're at 75. When it was first introduced in 1996, we were at 91. So this will help us to recover that ground. And it's not about judgments, because there is no question that our judgments and our judges, myself perhaps not included, our judges are without parallel across the world. But it measures those things that I just spoke about, which is a perception of accessibility, timeliness. It is not measured on whether people are actually getting it, but whether they perceive it. And so this is what we hope to address. Now, I could go on forever, but I won't, because it is in my report. And if you're at all interested, then you can read the rest of it online. Save for one thing. Just want to mention one bit of statistics, as I have to. I have to because of what I just said between Mr. Simon's figures for the criminal courts and Mr. McKee's figures for the cases. When I got my report from the clerk of courts, I took it to my sister and I said, "Your clearance rate is appalling." And she said, "That can't be right." And she went back and she looked and she said, "We've done over 100 cases this year." And of course, it tallies with what Mr. Davis has said. We've done 104 cases in the High Court. And I'm going to tell you why that's significant. Apart from the fact it's significant that our data capture is not perfect. And Mr. McKee gave his first submission to me, said that the civil jurisdiction only published 8 judgments, which I knew wasn't correct because I think I'd done 8 myself and maybe overbidding. But we discovered that there was in fact 39. I'm demonstrating the work that already needs to be done without even applying this questionnaire. But let me tell you what the figures do say, the ones that I do have. Note that the only information we capture is case disposition. We're not capturing anything else. We're not capturing how soon they're being disposed of. We're not capturing how many people were in custody before they were. We're not capturing that data. We're only capturing the disposition rate. So this is the good news, because I like to end on that note. And the good news is this. In the High Court, the Grand Court, 102 indictments were filed. In the same year, 104 were disposed of. That is a clearance rate. That's a case clearance rate in excess of 100%. Let me explain case clearance rates to you. A case clearance, it's a bit like she says, right? A case clearance rate of 100% indicates that the judiciary, the courts, can manage the cases that come into the system. Anything lower than that makes it abundantly clear that we're not coping with the number of cases that come in. If the court's clearance rate was 70% of 100, it would mean that every year 30 cases go forward. You can easily do the math and know that in 9 or 10 years of 30 cases going forward, we would have so many cases, it would take us 10 years to do them all. And the only way to avoid that is to ensure that you maintain your clearance rate at 100%, or if there's an existing backlog, that you have a clearance rate in excess of 100%. So I congratulate my sister, Richards, and of course, her able supplementary panel of judges who come on a very regular basis to assist in the criminal courts in particular. I really welcome this morning Justice St. John Stevens, who is here to assist in crime. And it is essential that the High Court Criminal Division continues to have a case clearance rate in excess of 100, because 77 cases were brought forward from 2021. If we don't continue or improve the existing case clearance rate, we will continue to have a backlog. Let us just quickly look at my friends in the summary report, if I have their figures. I do, but it's not here. Yes, it is. Hang on. In the summary report, crime, just focusing on crime, there were 872 cases filed, 943 cases disposed of. That's a clearance rate of 106%. If we were elsewhere, we would take off our wigs and go, woo! I'm looking at the Chief Magistrate and his team, because that's an exceptional job well done. You did carry 456 cases forward. So you had as many cases coming forward as you had filed for the entire year. But the prospect is still good, because as long as your clearance rate remains over 100%, you will make steady diminution, steady inroads on your backlog. It brings me to one last thing. I know I'm about to lose you. The last thing is this. The magistrates need to continue this momentum. They cannot afford the case clearance rate to drop below 100%. Now, I've been advised that the town hall, which has been used as a court since I came here in 1998, is no longer available. I make no criticism of the state. Apparently it is overdue for renovation, and so it should be. So what I'm proposing, and I discussed it with the Chief Magistrate, who may not have had a chance to discuss it with his friends, what I'm proposing is that we establish our first district court and locate a space in West Bay for the immediate purpose of handling the cases that would have gone to the town hall, but also for the purpose of using it as a pilot court. I think the benefit of such a court, if we establish a district court now to replace the town hall, it gives us the opportunity to explore district courts in Bodentown. These district courts would supplement what would now become the Georgetown District Court, all right? It doesn't require the establishment of any other registries. We're going paperless. Your registry is in your suitcase, your handbag, or it's in your computer, because everything will be filed online. So I don't need people in these courts to man up courts. You can file a document at Bodentown. Filing would take place as it does today, just like we do with the BRAC. You think people fly here from the BRAC to file cases? We take the cases to the BRAC once a month and we do them there. And the magistrates will simply, as we do in Jamaica, welcome to outstation courts, pack up the grip and drive to the outstation and sit. All right? And can I just say this? Anybody who has to drive to West Bay, that's a 20-minute drive. Some of us who come from larger jurisdictions had to drive upwards of 2 hours to get to the outstation courts. Roads that only cart and buggy should have attempted. I'm excited by this because the whole idea of, say, circuit courts and the whole idea, say, in Jamaica, outstation courts, is to take justice to the people. You don't have the public incur expense traveling to a central point to have their cases tried. You take the courts to them. And so that is what we're going to do. And I think it will be well received by the residents in the districts. It will ease the congestion in Georgetown. It surely is not right to have to park at Ale Thompson and walk to come to court because there's no parking in the neighborhood, right? I might have exaggerated, Pastor, but just might. Let's say end of Mary Street. And so this will ease the congestion in Georgetown. Let people not have to struggle to find parking. It will create court space without having to find any further space in the center of town for developing courts. And I think it will rationalize the delivery of justice. But I don't have to think, because we're embarking on the Court Excellence Program, and so I'll be able to measure. All right? I will not be thinking, I'll be measuring whether or not this initiative has the earmarks of success. All right, I have so much more to say, but it will have to wait on maybe till next year when I can report on my successes and remind you then about what I haven't said today. It's all in my report. So thank you very much for your kind attention. I'm going to invite you now to join us. Oh, yes, join us outside for some refreshments. And I just wanted to say that you will have noticed that Mr. Ruben Alberga is not here. This will be the first year, I think, 30 years? Longer? That he has not attended at an opening of the Grand Court. For as long as there have been openings, he has been here. But I want to assure you, he is still with us. He's just not here today. I understand, Ms. Alberga, he suffered a fall. I wish him, and all of us do, a swift recovery, and may we see him next year as ever. Thank you. I'm going to invite Mr. Josen to adjourn the court.
Silence, Oscar. This honorable court now stands adjourned until 2:30 p.m. today. God save the king.
For that pen mark.